So today, what we're going to look at is the most commonly used riders and addenda to the as-is contract. Okay. And these are for use with the as-is, not the commercial, not the vacant land. Okay. Although sometimes we do add some of these things, or at least the verbiage, into those two contracts. Okay. So we're going to take a look at them. It's just a few of them. We're going to talk about what do they really mean? When is the appropriate time to use them? What's the strategy in using them? How do they impact the terms of the as-is contract itself? And also make sure that everybody understands that a lot of these have critical dates that you have to pay attention to. And I have found through the years, and I'm sure Jeff has too, that quite often we don't realize that there are critical dates in some of these things until it's either we're right up against it or we haven't really paid attention to it. Now we may have a problem. So we're going to look at some of those things. And again, it's interactive. I welcome your questions, your comments, and so on. So the first one that we're going to look at, the first thing we're going to do is we're going to talk about definitions. What is an addenda? Okay. An addenda is a separate written document that you attach to a contract. Okay, so you can attach addenda to a contract a couple of ways, right? You can go into item 19, additional terms in the as-is, which I was going to put a copy of here, and I forgot to do that. And you can check a box, right? Lead-based paint, condo rider, any number of them that are there. Okay, and what those will do by now, if there's something you're going to add and it's not on that list of addenda, you can just manually add it to the contract in additional terms. So there are written documents that are attached. I prefer to use the term incorporated into a contract that you're adding to the contract, or it may be clarifying something in the contract or changing specific terms of the original agreement without having to rewrite the entire contract. A rider is also a separate document that adds to the contract or modifies a contract, clarifies specific terms, but when most times it's adding unique negotiated terms to the contract, like a backup offer, a backup contract, sale of buyer's property, kick-out clause, things like that. And those are the things we're going to talk about today. So that's the difference between the two. Okay. So the first one we're going to talk about is the sale of buyer's property. It's Rider V, and this one you can check off. It's in that list of addenda. So I would think all of you have used this at some point in time. Okay, so what does it mean? It means that the buyer needs to sell a property in order to purchase the contract, the deal we have in front of us, right? That's what has to happen. And they need to take the funds from that purchase to apply to the contract that we're talking about. Happens all the time. I have a few of them right now that we're dealing with. So the buyer needs the sale to close because they need the proceeds from that sale to purchase this one. The buyer won't qualify. He's working with the lender, but in order to qualify for financing, he is going to have to sell the property first in order to qualify to get financing. The buyer is avoiding bridge financing. I haven't seen bridge financing in a long time. What that is, they take a bridge loan to finance, to deal with both properties. Jeff, when was the last time you saw a bridge loan?
I'm not sure if I've seen one since I've been here.
Yeah, it
6
used to
years.
seem, yeah, I haven't seen one in a long time. So I wouldn't get too concerned about this. Now, the question is the buyer's property already listed or is it under contract? We're going to talk about that in a minute. A lot of times you will hear, because of the type of market that we're in, that there will be a 1031 exchange involved in this. So the buyer rather, who is selling his property may want to take those proceeds to avoid tax implications and put it in a 1031 exchange company and then move it into the closing of the deal that we're working with. Okay. What I did is this is the the clause in the as-is contract that describes what a 1031 exchange is. You're going to run into it all the time. Okay. We don't actually deal with it, but we just have to know about it. The closing agent is the one who's going to be responsible for dealing with the 1031 exchange. Okay. Okay. This is the provision in the contract, and I've highlighted those things that we want to talk about today. So taking a look at it, the contract is contingent on the sale and closing of the buyer's property located at, pretty simple, you're going to put the street address of that property in here. Okay. Upon entering into a contract for the sale of the buyer's property, the buyer shall give the seller a copy of such contract with the third party's identification and purchase price information obliterated. But the question is, okay, is the buyer's property under contract? Yes or no? Okay. So if they say it is, then again, the copy of the contract needs to be provided to the seller. It has to be provided simultaneously with the offer that you're writing or within 24 hours. So what we're saying here, though, is you're going to provide that contract, but you're going to obliterate or redact the purchase price on that contract because it's not our sellers really any of their business what the purchase price is, and you don't want that to influence the seller's decision, right? And also the identity of the parties involved in the purchase of the buyer's contract. I think that makes sense. So he's under contract, and now you have to insert a date in here. If the sale of the buyer's property does not close by X, okay? So now the buyer has to tell you when that property is going to close. Okay? All right. Buyer may, within 3 days thereafter, deliver written notice to the seller terminating this contract, in which event the deposit will be refunded. So if it doesn't close by that date, the buyer then has to notify the seller with written notice. Okay. And then they will get their deposit back. And then the buyer and seller are released from any further obligations under the contract. What happens though if the buyer fails to deliver written notice that they didn't close?
Don't they have to
Anybody know?
pay cash?
You've just moved into a cash transaction. You've removed this contingency. Okay. So if you were a seller and you received an offer and you had this contingency, what would your thought be if the buyer's property is not under contract? If you were in the seller's position?
I wouldn't suggest they do it.
Okay. Would you ask the question, well, is it at least listed? Okay. And if the answer is it's not under contract, but it's listed, would you want proof that it was listed?
Yes, and I'd kind of look at the market to see if it was listed well.
Right. Okay.
Price.
Yeah. So you've got it is or it is not under contract. If the buyer's property is under contract at the time this offer is made, then the buyer's got to provide the seller a copy of the contract with third party's identification and price information obliterated simultaneously with their offer or within at least 24 hours after the buyer's offer is delivered to the seller. So, I just gave you some bullet points here that just talk to what I just went through with you. And again, if it does not close by that date that you've inserted in the addenda, the buyer has 3 days to deliver written notice to the seller terminating the contract. Okay, that notice is what? It's a release and cancellation for the seller to sign.
Ruth, it's Lauren. The way I've done this once, and I was just wondering if this is the norm. I had someone that was selling their home and buying another home, and so the sellers of the home they were buying accepted a home sale contingency, and we did it with a kick out. That way, you know,
We're getting to that, Lauren.
okay, perfect.
The next thing is going to be the kickout clause.
Perfect. I was just wondering if those usually do work in conjunction.
They do.
Okay, perfect.
They
Thanks.
do. Yeah, they absolutely do. Does anybody have any questions about what's in this rider and what the seller and buyer, how they work together with this and the timeframes involved? No? Okay. Because you will see it a lot. Okay. We just went through one last week, which was contingent on the auction, a successful auction of buyer's property. Okay. So we used this, it was the sale, obviously the sale of the buyer's property, but it involved an auction. So that became very interesting in trying to establish a closing date for that deal. So one of the things that we wanted to do is when it actually did go under contract, but there were different stipulations in that contract because it was an auction. So we asked to review the entire contract before we settled on a date here. So I would tell you, you may want to ask to review that contract that your buyer has to make sure that they know how to establish that closing date. Okay. All right. Okay. What are the consequences if the buyer fails to deliver written notice of termination, which is a release and cancellation to the seller within 3 days of the buyer's failure to close? The contingency is waived. The sale of buyer's property contingency expires, and the buyer is now bound to perform under the main contract. And of course, their escrow is at risk. So again, these are dates that you have to be on top of. Okay. So the seller, what is the strategy for the seller here? They should require that the buyer's property is under contract. But again, if it's listed and you look at the market and you see what days on market are in that area and you feel confident it will go under contract, maybe they will accept an offer where it's listed. But at minimum, it should be listed. We're going to add the kickout clause, which Lauren just mentioned. We're going to talk about that. Maybe your buyer wants to shorten contingency timelines. Maybe they're going to request a copy of the listing agreement if it's only listed. And maybe they're going to ask for an increase in escrow to offset the risk. So those are some things from the seller side. From the buyer side, your buyers need to be transparent about the status of their sale. They need to keep timelines realistically, and that's what we just did on this deal where we had the auction involved, determining closing dates and so on that were realistic because we had to deal with the provisions in that contract. Pair with strong proof of funds or backup financing and understand exactly when you can cancel without penalty. Okay, so the buyer needs to understand how this works, okay, and their risk. Okay, so Lauren brought up the kickout clause. This does work with the sale of buyer's property. That's what it's intended for. So we will take a look at that. Okay, it's used primarily with, as we said, a sale of buyer's property contingency. The seller doesn't want the home tied up indefinitely, so that is, benefit to the seller. Market conditions favor sellers a strong backup interest. So again, this gives the seller a lot of flexibility. And in Florida, it's typically paired with the sale of buyer's property addendum. The kickout clause allows the seller to continue marketing the property and accept backup offers, which we're going to talk about next. When the buyer's contract is contingent, most commonly on the sale of buyer's property. If the seller receives another acceptable offer, the buyers give a short window to remove the contingency or terminate. So we'll talk about that. So Lauren, you've used a kickout clause. Anybody else but in this situation used a kickout clause?
Yes, I have.
I have used it. It's been a
Natalie?
while.
Good morning, Natalie. Good morning, Melissa.
Good morning.
Okay. Okay. So here's our kickout clause. All right. So there's risk with the sale of buyer's property unless you're in a situation where it's about to close. Okay, there's still risk there, but there's a lot of risk if depending on where that other contract is, is it in inspections? What are the contingencies in that? How risky is that contract? So to protect your seller, you want to use a kickout clause. So you can continue to show the property and you can solicit or enter into backup offers. Okay. So what happens if the seller decides to accept a backup offer when you use the kickout clause? Okay. Well, the seller now has to notify the buyer and give them a copy of that contract with, again, third party's identification, purchase price information obliterated or redacted. So now the seller's going to put the buyer on notice that I've got another deal, right? To continue with the primary contract, which is the contract that we're talking about here, the buyer must make an additional deposit of X. So they have to increase the escrow. There has to be a second escrow deposit. Okay. Within 3 days from receipt of the backup contract. Okay, so 3 days from when the seller delivers that backup contract to the buyer has to make that second escrow deposit. So by giving the additional escrow deposit within 3 days, the buyer waives all contingencies for financing and sale of buyer's property and will close. Okay. And that additional deposit obviously is going to be credited to the buyer at closing. If the buyer fails to timely make the additional deposit, then this primary contract shall terminate and the buyer will be refunded the deposit. Okay. Is everybody clear? So what happens here is when the buyer is notified and then makes that deposit, their deal is protected. Okay. Now the question is, and this came up last week with Rick Lively, and do you think you have to put a dollar amount in here?
Yes, I would think you have to.
Would
You
think
don't.
so.
Under Florida law, you don't.
Yeah, and it doesn't have an autofill either. So
No. Under Florida law, you don't. So the discussion because Rick had one where he didn't have a dollar amount in there, and he called me about it because they were looking to enforce it. And I said, well, I don't know. I said, there's intent here. I said, it's probably you can probably go forward with it because of the intent. So I asked him to call Greg Orpeza, and Greg came back and said, no, you don't have to put a dollar amount in there. And again, but the intent is there, so you can enforce the contract. Okay. So I'm going to we'll talk about that in a minute. So most times though, the seller is going to want to see a second deposit in there. Okay. All right, because that puts pressure on the buyer to perform. At the time the primary contract is written, the buyer and seller will agree on the amount of an additional escrow deposit to be made should a backup offer be received. Upon entering into a fully executed backup contract, the seller will give the buyer a copy with third party's identification and purchase price redacted. To continue with the contract, the buyer must make the additional escrow deposit within 3 days from receipt of the backup contract. By doing so, the buyer waives all financing contingencies and moves to closing. If they don't make the additional deposit, the contract terminates and the buyer is refunded their escrow. Okay. So this gets to, can you use the kickout clause and leave the dollar amount for an additional deposit blank? Yes, because it's not required. All right. Because theoretically, there is no relationship between kickout clauses and escrow deposits. They're separate in terms of the contract. So what does the kickout clause do? It controls the seller's right to continue marketing, sets a notice and response timeline, and determines whether the buyer must waive the contingency or terminate. It does not automatically change escrow terms. Is everybody clear on that?
Yeah,
So if
but
they have to, so if they have to waive all financing contingencies, that means that they basically have to pay cash.
They move to closing. Yeah. They move
They
to
don't
closing.
have to pay cash, they just have
No.
to waive the contingency.
Yeah. They're
Yeah,
just they're moving to closing. That's all.
Mhm.
But they don't have the contingency to protect them.
So if you're
Okay.
saying there's no additional deposit required, then is just notification that, yes, we're moving forward? Like what would trigger the first one being kicked out if there's no deposit needed? Because that's how it reads, like a deposit is signaling it.
Right.
So,
But under, when we enforced it last week, it was very simply exercising, here's a copy of the backup offer. Okay. And the buyer had the right to say, I can't move forward. And that was it.
no, but what if they want to move forward?
Well, then they waive the contingency.
Oh, okay. Okay.
They waive the contingency. So it really gets down to intent. All right. Um, it was interesting. It was interesting because the first time I had run into it, every time I've used a kick out clause, I've always had a secondary escrow in here. So Rick was able to enforce um, uh, the rider. So
Can you explain how the dates work with that? Because that could have been sitting with the kick out for months, and then you say proceed to close, and what closing date is used? Is it
you
like,
have your you have your closing date is in the other contingency. Remember, you works in condition in combination with the sale of buyer's property.
oh, there's a in there that says you're going to close on this property by a certain date also.
Yeah, in the because these two are used together.
Can you show it again real quick? The kick out.
Kick out or okay. Kick out talks to a secondary escrow and the seller providing a copy of the backup offer to the buyer, which then triggers the buyer as to whether or not they're going to move forward, make a secondary escrow deposit, or are they going to move forward and waive this contingency. The sale of buyer's property has the closing date in here. Okay, as to when the sale of the buyer's property is going to close. But in the basic as is contract, you have your closing date.
May I interject something to confuse everybody?
Certainly.
So what I would probably do, and we run into this occasionally when the house may be on the market and it may not be under contract and it may take 3 months to sell. So how do I guess what the closing date's going to be to put on the as is? If you define the effective date inside the as is or somewhere in the documentation, define the effective date shall be the date that the buyer waives the sale of buyer's property contingency. Then if you put all your dates in, your financing date is 30 days from effective date, your closing date is 45 days from effective date, then everything will follow suit back to that. So that's one idea that you could do. I think that will answer Annalise's kind of question a little.
Yes. Yeah, that does. Thanks.
Yeah.
Kind of like a
Yeah.
short sale. If you think of a short
Yeah.
sale,
It's like a short sale. Yeah.
it's in the addendum. It says the
Mhm.
effective date shall be defined as the date the bank approves a short sale,
Right.
right? There's one other addendum that redefines the date, and I think we're going to talk about that. But that's a problem you're going to have
Yeah.
if it might be a 3 month closing. How are you going to effectively figure out when it can close? Well, you can't. But if you make it a function of the date that the buyer waives the sale of buyer's property contingency, and you make all the dates in the contract a function of the effective date, then that should work out for you. Does that make sense?
Yeah, I totally
Yes.
understand that. Thank you.
Yes, I like that. That does make sense.
Ruth, this is Christy. What I've done in the past, and I'm is say in the original as is, I'll say closing shall be within 10 days of closing of buyer's property, something like that. Would that, but I guess I could say closing will be within 10 days of the sale of buyer's property, or whatever language you use to say that we're signing off on it. Would that work?
The problem
Yeah.
becomes, how do I deal with the inspections, right?
Oh,
If I don't even have a contract on my house. Am I gonna pay, $1,000 for whatever and pay for this and pay for that, right? So unless you change, you know, you think about all that too.
Well, the
well, I've always
inspection
done
should
it.
have been done, right?
Yeah,
Before,
I'm doing it. The inspection has already been done. Like I'm moving when I've done it, and I'm doing one now, expecting that, or I'm writing one now, expecting that the buyer, I have the buyer, is going to do the inspections and do the loan approval and at least get that far. And now we're just waiting for the sale of the buyer's property. I mean, as a listing agent, I would want that to start right away.
So it depends on what side you've got probably. And
Exactly.
Yeah,
Yeah.
because on the buyer
what-
side, you
what
don't
the
want them
risk-
spending that money
yeah,
ahead
what
of
the-
time,
What the
right?
risk tolerance of your buyer is and
Mhm.
how, real estate's an art. There are many ways to practice it. So that's a great idea, Christy. And I'm not saying that that's not the way for you to go, but it's not the only way. So
Thank you.
that makes sense.
Everybody good? Yes, no?
Yes.
Okay. Okay. Okay, on the kickout clause. Okay. Are we good on the kickout clause? Okay. All right. Now we go to the backup contract. It's interesting because I've gotten a lot of phone calls in the last 2 or 3 weeks about backup contract. So we're going to talk now about that. When do you use the backup contract? Okay. Contingencies in the primary contract, sale of buyer's property, amount and timing of escrow, length of inspection period, extended closing. You've gotten a couple of offers. You're in that situation where, you have a couple of offers. You have concerns about financing, about the buyer's ability to obtain financing. You may have some concerns about appraisals. Maybe the seller wants more leverage, or the market is slowing. Okay. And you may have some concerns about, like, say, the financing, the market slowing down. You have to, offers are not coming that easily. So you want to make sure you lock in a backup contract. Okay. I'm sure all of you have dealt with this. So it lets the seller accept a secondary offer. All right. But it only becomes an effective contract if the primary contract terminates. Okay. And once that happens, the buyer then moves into first position. So what is a backup contract? It's a fully executed contract. It's just not effective. Okay. So fully executed means it's signed by buyer seller. You've got all the addenda in place, because remember, you don't have a valid contract if you don't have all your addenda back. So it's sitting there and it's fully executed. All right. But it's not effective. And so here's the clause for the backup contract. It's subject to the termination of the prior executed contract between between the seller and a third party. If the prior executed contract is terminated, that's the primary, and the seller delivers written notice of termination to the buyer on or before. So this date is what? Somebody tell me what this date is?
Effective date?
This date is, how long is the buyer who is submitting the backup contract going to, it's really the validity of the backup contract. How long is the buyer going to wait to see if they can move into primary position? That's what this date is. So the buyer may say, you know what? I'll wait 2 weeks because we know the other one's an inspection, and we think and maybe it'll fall out during the inspection period or whatever. Maybe it's 45 days to see if it closes, whatever it is. But this date is the date that the buyer has decided that he will allow the backup contract to be in place. Okay. Everybody clear on that? Okay. This contingency shall be removed and this backup contract shall move into first position when the seller delivers a written notice of termination to the buyer, the written notice of termination of the primary contract. And that has to be a release and cancellation for that contract. Okay. Once that happens, and this is what the buyer has to understand, once the seller delivers that release and cancellation on the primary, and it is delivered on or before the date that is here, okay, not after, because if this date expires, the contingency is removed and the backup contract is terminated. But the seller delivers that notice on or before the date in this contract, then the backup contract moves into first position and it automatically becomes an effective contract now. Okay. The effective date of the backup contract then becomes the date that the seller delivers that written notice of termination. Okay. So if you get the release and cancellation today is the effective date of contract, not the date that's on the release and cancellation. I just went through this the other day. Okay. It's the date that the seller delivers it, not the date of the actual release and cancellation. Okay. So now the buyer is in first position. So what happens? We can move on. Let me take a so you've got that date in there. Contract can move into first position. But what happens? Let's say the buyer decides he's going to put a 3-week, 21 days, a 21-day validity for his backup offer. And he gets like 3 or 4 days into it, finds another property and says, you know what, I want to withdraw this. Can the buyer do that?
Yes.
Yes, they can. Yes, they can, but through written notice that they are going to withdraw their offer. They can do that. Okay. But what happens? But the buyer has to understand that once the seller delivers written notice within that time frame, they're obligated. They cannot terminate the backup contract. They have to move forward. But what if they decide that they, I missed the date, the seller delivered notice, I really didn't want to move forward, they can get out because they're going to move into the inspection period, correct? So they could get out during the inspection period. Okay. Okay. The question is, now we've got an effective date. So the effective date is the date that the seller delivered the written notice, the release and cancellation on the primary. So everything starts from that date. This is the effective date now of your contract. So everything, as it normally does, flows from that effective date. Escrow deposits, closing dates, inspection periods, loan approval, everything else that's in the contract. Okay. Anybody have any questions about that? About how this works? But a backup contract has to use this addendum. It has to be identified as a backup contract.
Ruth, I have a question. So let's say that this backup contract is on one of our listings. Are we obliged to tell the buyer's agent that there is a backup offer in place because it's kind of a multiple offer situation? Or if this backup offer is this still a multiple offer situation if the backup offer didn't come in until after the primary folks were under contract?
So your question is, are you obligated to tell the other agent when they submit the offer? Or are you saying, or I guess, Mike, what is your question exactly, Christy?
My question is, let's say I have the listing and, 1, 2, 3, French Street goes under contract. And then after it's under contract, I get a backup offer because it's under, it's contingent show. I get a backup offer. Am I required to tell the primary buyer that there is a backup offer, or should I do I not need to tell them?
Tell them.
I would think
sorry?
it would behoove your
would tell
seller
them.
for them to know, that way they don't,
I would tell them.
they don't try to cancel on you.
Yeah, I would definitely tell them.
Okay. In the past, I've kind of just like felt it out. Like I've said it if I felt like the time was right and I needed to, but I just wasn't sure if I was required to.
Well, what if you have a situation where the backup offer is better than what the contract is? Then would it be better not to say anything because maybe the first people will drop out and the second contract is better for your seller?
Good point. Yeah.
Yeah. Yes.
There's nothing, there's nothing that says you have to.
Okay.
Okay. There's nothing anywhere that says there's no legal component that says that you have to notify them. I think it's a judgment call. But there's no
Yeah, I
reason,
think you're doing it right, Christy. Tell them if it helps your client.
Yeah.
The negotiating tool, or
Yeah,
can be used as one.
Mm-hmm.
Thank you.
Mm-hmm. But again, it's a judgment call, but there's nothing that compels you to have to do that. So, but you can tell them. I mean, there's no, I think you have to make that decision. Okay. Buyer can terminate the backup contract at any time prior to the expiration date of that's in there. But again, before the seller delivers written notice of termination, it's very, very similar to the language in the contract that deals with counteroffers. Okay, and with when counteroffers can be withdrawn. So, and just general offers, initial offers too. Okay, so and the escrow will be refunded to the buyer. Okay. Are we good on backup offers?
I know, Ruth, we were saying, there's not as much risk for the buyer to put in a counter offer if they have an inspection period. But I know personally, I've had an instance where if you're going to submit a backup offer, you probably really care about the property and you probably are going to go in strong. And then it is a little stressful waiting for them to execute if you submit an offer with no inspection and it's cash, because then you don't, the second they notify you, you're in first position, you're on the hook.
That's right. And that's the thing you have to explain to your buyers, just exactly, and make it clear to them that that's what happens. This is what you're entering into. So you need to understand how it works. If you do change your mind and you want to withdraw it, you've got it you need to know that here's the date and you have to take action before that date. Once the seller delivers that notice, you're committed. But
yes.
But you always have the escape of the inspection period. So you do have an out.
If you put an inspection period.
If you don't put an inspection period, which I'm not a big fan of, okay? I'm not a big fan of going with 0 days in the inspection period. For just that reason.
Yeah, maybe it's just even if they're a buyer who says we don't want to do inspections, as an agent, maybe just recommend like do 2 days or 3-day inspection period, just so you have that period of time. If
say I did it personally, it was myself. I mean, if a house is on the market for a cheap price, check it out, and you sometimes go with that risk.
Absolutely.
Yeah, I always, when I'm doing this, I always recommend that we put an inspection period in there for 3 days. Okay, because you don't know what's going to happen. You don't, things change, and the buyer, I don't like to see anybody locked in.
I think as long as we've explained that and tell them the risk, and then they still decide we don't want to do it, then.
Yep.
Well, again, your job is to explain risk to them, make sure they understand how the entire contract, how it works, what is it that impacts them, and then they make their own decisions based on you taking them through the contract, explaining everything to them, And if they say no inspection period after you've done that, well, that's their right.
Yep.
But our job is to provide information and allow people to make informed decisions. Because you don't want it to come back to you later on with, why didn't you tell me? Or why, I didn't know. You never want to be in that situation. Okay. All right. Moving on to pre-closing occupancy and post-closing occupancy. Two things that I do not recommend for lots of reasons, but they do happen. I have one this week that we have a 3-month pre-closing occupancy. And the interesting part is we also have, this is where we have the auction of the property. And in the contract, we have sale of buyer's property. So, okay. So how many people have gotten involved in either one, pre-closing or post-closing occupancy deals?
Yes.
Yes.
Yes. Everybody goes,
Never.
yes.
I'd love to
Yes.
hear
They're
about
not my
them.
favorite, but yes.
Not my favorite either.
No.
Okay, so pre-closing occupancy is really high risk for the sellers for lots of reasons. So you really want to understand why the buyer is suggesting a pre-closing occupancy. What is it that's surrounding the buyer that they believe that this is something that they really need to do, and they're going to make the deal contingent on it. So what we see a lot is buyers renting somewhere and their lease is ending before the closing of the sale. Or they sold their house already, they closed on it, and they have nowhere to live. Or the closing is delayed by the lender or a title issue. And Greg Orpeza talked about title issues and cure periods last week. So, cure periods on title can go up to 150 days and delay closing. Buyers get emotional sometimes. Okay, that's kind of what we're dealing with the one I have this week with pre-closing occupancy. There are a lot of issues. It's not as though the buyer doesn't have a place to live, but there are other personal issues surrounding their need to be in Florida. Okay. So it's very emotional. They need to be in Florida and in the Keys for personal reasons. So that can enter into it too. And then you get a lot of emotion surrounding this with the buyers who feel that this is, whatever it is that's pressuring this, they can get very emotional about it. So you have to try to keep the emotion out of this. And unfortunately, this week we had a lot of emotion surrounding this. So it just kind of clouded some of the thinking on the seller side. So here it is. Okay, the pre-closing occupancy. You're going to have this in the contract, but we are not going to create the agreement, whether it's a lease or some kind of pre-closing occupancy agreement or some agreement between buyer and seller. We're not going to get involved in that. Okay. So what I do is I turn it over. When we do this, we have the attorney with the closing agent develop the agreement, whatever the agreement is. We're not going to do it. There's too much risk for us. So under this, the buyer and seller have, and the default is 10 days after the effective date, to have a mutually agreeable agreement of some kind, lease, whatever it is, in place. Then that gets to who's going to pay for that? Who's going to pay for the drafting of the agreement? Is the seller going to pay for it? Is the buyer going to pay for it? Or are they going to split that cost evenly? So that is a decision you have to have. Okay. And then the date for the buyer to take possession of the property. So you're going to put a date in here. Okay. When are they going to take possession? So now the buyer is taking possession. Now we have to look at paragraph 11 and paragraph 12 in the as is, which deal with maintenance and who's responsible for maintaining the property. So in the pre-closing agreement, and the buyer takes possession, paragraph 11, which is property maintenance, and paragraph 12, which is inspection and repairs, they are no longer applicable, and the buyer is accepting the property in its existing condition, which is going to relieve the seller of any repair, replacement, treatment, or remedy obligations, except any items that were identified during the inspection period in the as is, and there was an agreement between buyer and seller as to whether or not the seller was going to go ahead with repairs, whatever it is. But those would have all been agreed to during the inspection period and documented. So those are still in force. Okay, but the seller is no longer required to maintain the property, to physically maintain the property. Okay. So it's a situation where the buyer goes into the property and now they find things that they didn't find during the inspection period, and they think they have the right to come back to the seller for the seller to deal with those things. They don't. Okay. But the seller, okay, no longer has to deal with this. He's relieved of all of that. So so it's too late for the buyer to come back and say, well, I didn't find this, I want him to fix it. That's not going to happen. Okay. So the buyer is taking possession, and the seller is relieved. And then the buyer shall have the sole obligation of maintaining the property and shall assume the risk of loss. And then here we're going to they talk about, okay, what is the rent going to be, plus any applicable sales tax or other fees. So they have to agree on what the monthly rent is going to be. All right. So if the parties fail to mutually agree to an agreement within the time period that stated above, and the buyer has not taken occupancy, then either party can terminate the contract. Okay. So pre-closing is definitely high risk for the seller. Okay, so until closing happens, the seller owns the home, so letting a buyer move in early creates a serious legal and financial risk. The actual agreements to be drafted by the closing agent attorney, not the agent. The rider outlines the basic terms. We just looked at it. Who's paying for the drafting of the agreement? What's the date of occupancy? What's the rent? And then they've got 10 days or any other date you put in there, but 10 days is the default for it to be in effect, 10 days from the effective date of contract. Okay.
Oh, sorry. I'll wait till you're done.
Go ahead.
I'll wait till you're done because I want to go back to the addendum. I just had two questions.
Okay. So when the buyer takes possession of the contract, provisions 11 and 12 are no longer applicable. The buyer is accepting the property as is. Okay. And the party fails if they fail to mutually agree to the pre-closing agreement, with whatever time frame you've used, then it's no longer in effect and the buyer's escrow will be refunded. So you wanted to go back to this?
Yes. Where was so I understand the pre-closing agreement, kind of on the second highlighted portion. The for taking possession. Now, before that date, the possession, because I mean, could you do a walkthrough prior to that date if you agree on it? Like, because I've had things not come up during the inspection period, and then at a walkthrough, I've had water leaking or something along those, like something that obviously you couldn't have seen in the inspection period. Could you do or put something in there that you can do a walkthrough prior to them taking the possession, and then all the other terms come into play? I don't do this very often, but it was just something I thought about.
You're thinking similarly to what you do a day or two before closing.
Correct. Yeah. Like,
Similar
if
type of
you were
thing.
actually closing, because after this date, the buyer is going to be responsible for it, obviously, or the property. So, could you do something like that? Or is that the attorney question? I guess it just has to be agreed
I
upon.
suppose you could. I suppose you could do a walkthrough. I suppose you could. But again, whether or not, because the intent is different here. You're not closing. You're
Correct.
coming in as a tenant. So it's going to fall under landlord tenant provisions. See, it's different.
Right, because in the contract you have that a buyer can have a walkthrough.
Correct.
So that's kind of where I guess my question
I
is,
would
because
think,
you waive
I
the
think,
walkthrough.
I think, well, it does, yeah.
Yeah.
It does. So I think, yeah, I think I've never had anybody ask me that question. So I would think,
Leave it to
uh,
me.
yes, always. Um, yeah, I suppose you could, yes. I
Okay.
don't see why you couldn't.
Would you have an addendum signed by both parties?
Excuse me, sorry.
What, to be able to conduct the walkthrough?
Yes.
The walkthrough is in the as-is contract. Jeff, what do you think? I don't see,
Yeah, what paragraph is it in? Because if you look in this addenda right here in front of us, it says, you know, the seller's relieved of everything except with respect to any items identified pursuant to paragraph 12 prior to taking occupancy, which require replacement, treatment, or remedy. So anything that the parties have agreed to fix has to be fixed.
right.
Uh,
Yeah.
Right,
and
I get that, but then so
I
you
think you could, I think that would be a reasonable expectation to ensure that those things are done, you know.
Well, here's the thing. I mean, how much time did you give the seller under the as-is to do the repairs? You know, when you documented any repairs coming out of the inspection period, did you just say before closing? Because the seller then has that time, because anything you documented under this on the as-is stays in place.
Mhm.
yeah, because it's in the standards, it's line 506L, just it
I
for the
know.
access to the property. It just says seller
Mhm.
should, upon reasonable notice, utility service, appraisals and inspections, including a walkthrough, and then in quotations, or
Right,
follow-up walkthrough if necessary prior to
prior
close.
to closing, but that's prior
So
to
it doesn't,
closing. Now you're
I mean,
talking about, you know, a different, a shift, the having a pre-closing occupancy agreement, there's a shift now. The relationship between seller and buyer is different now. It's tenant and landlord. So I don't know. Um,
I mean,
and
I would think that if the parties agreed to a final walkthrough prior to the pre-occupancy, the pre-closing occupancy, I mean, if
Mhm.
it were me, I would think it would be in an addendum and signed off on in writing so everybody knows that it's agreed to. And I guess I mean, it's advantageous for the buyer, but it's could be a disadvantage to the seller. So they may be like, no, I don't want to do it. But I guess you just have to see where both parties are at.
yeah.
Yeah, I agree with you. I
Yeah,
agree
'cause
with you.
I mean that, like, it only talks about 11 and 12 being
Hmm.
overridden, so to speak, but you still have that standard in the contract.
Well, but the 11 and 12, he's
They
relieved
want the
at,
seller might not have to do it. Like, it doesn't say the seller has to do anything, but you know what I mean, like in
I
that
know
sense.
what you mean. But remember, it just the key thing here is anything that was agreed to during the inspection period and
Yeah,
documented in an addendum, that's still in effect.
correct. Yes. No,
Okay.
I do understand that. I've just, like I
Yeah.
said, I've had some off the wall scenarios where literally the day before closing, I had a water leak from the from the roof.
But
So like a big scenario like that, I guess, is what I'm really
Sounds like
asking.
a lot of ambiguity. I'm going to try to avoid these in the future.
that's
Oh
the
yeah,
whole
I don't like to
thing.
do them at
The
all
the
for
whole
the
point of this is trying to get to agree that we do these as infrequently as possible.
yes.
Okay. Um,
Yeah, I
All
mean,
right.
I had one yesterday. We have a contract on my Navajo, and the agent was like, could the buyers rent the upstairs prior to closing? And I said, well, I know my sellers are going to ask me what they should do, and my recommendation is going to be heck no, don't do it. And
don't do it.
they were already in agreement with that, and the agent understood. She said I would tell my sellers the same thing. So
Mhm.
just try to avoid it if we can.
Have you ever seen this happen where pre-closing occupancy was allowed and something came up where the buyer felt like the seller should have known of the defect and it causes a legal issue?
Thing is, the overriding statement in the addenda is that the buyer is accepting it as is.
I know, but
Now, if you,
I feel like
if
it's
you're,
something they knew they should have known and didn't disclose.
and now you're talking about a material defect that wasn't disclosed, and
Yes.
now the buyer's living in the property and they discover it.
Right. Have you ever seen that cause a problem?
No, I have not. Maybe Jeff has. I haven't seen that happen.
Yeah, but I've
But
had.
again, I think that then becomes a legal issue because now, the contract is very clear that the seller has to disclose any material defects. But then you have this that says the buyer is accepting the property in an as-is condition. So that,
I would
I don't,
issue.
I think you could probably um do something with the seller about that. I think because you've got the contract that says that it has to be disclosed, and if it wasn't, I think that's a very interesting question, and I don't know that I have the answer to that. Jeff might, but I don't know that I do. So
I'm sure that these things are a bad idea. Just don't do it. You won't have to worry.
exactly, just don't do it. Because then you've got the other scenario. You've allowed the buyer in the property, and I don't get too concerned if the buyer's only going to be in there for a day or two or a week. But if I've got the situation now, we've got one where they're in for 3 months. Um, I don't like it because what happens if the deal doesn't close? Now what? Now you've got to remove the buyer from the property, correct? So that's another whole action that has to take place. And now you have the risk of damage to the property. You've got all kinds of things that you're up against if it doesn't close, and now you have to remove the buyer from the property. You've got deferred maintenance, you've got all kinds of things, right? Damage to the property, deferred maintenance, and then just um, getting them out of the property. And hopefully you don't have to get into an eviction scenario. Hopefully you don't have to do that. So, I mean, the risk is quite significant in my view. So now we've got the other side. We have the post-closing occupancy. Language in this is very similar. What would initiate, a seller to want to stay in the property? Okay, so it's closed. The seller is now a temporary tenant. Normally what we've seen is the seller is not ready to move. They need some more time to pack up and move. Maybe the house that they're going to is not available yet. Maybe there are construction delays involved in that. Coordination of back-to-back closings, we've had that. So there's a few things that might the seller may feel that they want to stay in the house for a few days. I don't like this one either. Okay, for similar reasons. The language is very similar. Okay, they have 10 days prior to closing, okay, to come to terms on an acceptable agreement. Language is exactly the same, who's going to pay for it and so on. The post-closing agreement will provide the seller shall pay a monthly rent of X. But up here, the seller will remain in possession of the property until, so here's your date. This is the date that they have to vacate. Okay. The seller's maintenance obligation under paragraph 11 shall continue after closing. So now the seller is obligated to continue property maintenance. Okay, as prescribed in paragraph 11. Okay. Until possession of the house is delivered to the buyer. However, seller's repair, replacement, treatment, and remedy obligations under paragraph 12 shall not be extended beyond closing. Okay. 12. Everybody clear on that? They got to maintain it, but any obligations under 12 do not extend beyond closing. So all of those repairs or all of those things that you found during the inspection period and you documented in an addendum, the obligation to the seller to do that, if he hasn't finished it, ends at closing. It does not go beyond closing. Okay. And it's the same thing. If they don't come to agreement, they can terminate the contract and buyer gets their money back. So it's this, basically the same thing. Okay. So here we get the same problem. If the seller does not vacate on time, the buyer must pursue eviction in court process. They must, they don't have to, but it's a possibility. The buyer owns the property, they're paying the mortgage probably, and they can't move in. So they're paying mortgage payments on a property that they're not in. Again, you've got risk of damage due to the seller moving out. You've got some liability issues because you have to make sure that insurances cover all of this, because now you have a landlord tenant situation. And for the period of time that the seller is in the house, you've got deferred maintenance. So there's a lot of high risk with this one as well. So the advice is don't do it. Don't do either one if you can avoid it. Okay. Questions about anything we talked about today? Yes, no? Any one of these that we talked about?
So one thing I see you guys do is, and I've seen it in all the offices up and down the Keys, you guys will write in the additional terms, seller to retain possession of the property for 3 days after closing, right? Or seller to remain in the property for 1 week after closing, right? That's the very worst thing that you can do is just
Absolutely.
handwrite that in and, hope for the best. Any settlement agent, attorney, titled attorney, these guys all have these, and girls have these pre-closing and post-closing occupancy agreements.
Mhm.
Ryan Bond up here, all I got to do is press a button and it spits it out, right? They put the data in, they charge maybe 175, $250,
Yep.
and it absolves you of all liability in regard to screwing that up, right? The other thing I've seen, and this is in Key Largo, I see occasionally somebody will do a post-closing occupancy and they'll take a Supreme Court approved long-term lease and fill the whole thing out and execute it for 1 month, right? What problems does that pose, right? How about sales tax? I mean, what about the sales tax number? What about the short-term vacation rental license? I mean,
Yeah.
you just don't want to get involved in any of that. So,
No.
So
the post-closing occupancy agreement, so like the only time that I would really recommend that would be if you've got really shaky buyer with financing, right? And you've got a seller that absolutely has to know that this is going to close or they can't, you know what I mean? I mean, we've had situations where people have packed up and moved out, and then all of a sudden you get all of a sudden it doesn't close, then everybody's mad at us, right? So, if you got really shaky buyer or shaky financing or a bad lender, you may want to consider post-closing occupancy for the seller for just a very short period of time using this addendum and a post-closing occupancy agreement drafted by somebody other than you. Does that make sense?
Points. Yeah, it's insurance. It's really insurance for the seller.
Yeah.
But Jeff is right. All of I know Patrick Stevens, Tony Barrows, Greg Oropesa, they have these, as Jeff said, they already have these and they can just press the button, print it out, fill it out, and we're done. Okay, so it's not a major effort on it, and whatever their fees are for it. But if you're going to do this, use the riders, and make sure, that you're going to your closing agent, okay, and have the attorney take care of this. Don't get in this. Don't, whatever you do, don't try to write up something yourself, okay? Because it's not something that's within our purview.
You're not licensed to write a
Nope.
short-term lease.
Nope.
That's an unlicensable activity for you. So
Mhm.
Jeff, were you saying that this is something you would do when for post occupancy for the seller is when you have a shaky buyer and you don't want them moving all their shit out too soon. So it's giving them just a little extra time after contingencies are met and it's pretty solid, then start moving.
right. I mean, if I had,
What he's
a
saying.
90-year-old lady that had, or just a situation where there was a lot of risk for the seller if the buyer didn't close, and I knew that the buyer was a really high risk buyer for whatever reason, that's the only time I would kind of go into this kind of a
Yeah.
scenario.
Okay.
And then dependent on if if it's my seller, right? What side are you on? What's your agency with that person?
Mhm.
Right?
So,
But in,
question that doesn't really pertain to the sales side, but my side as the rental agent, because this does happen, should I be asking if they have the pre-closing occupancy? Like in a scenario where the agent contacts me, and this has actually happened 3 times last year. Hey, the buyer is going to stay in the property. Are these dates open? Then what does that translate to for me? I always say I think that's the dumbest idea ever because I mean, you know, if they're not out of their inspection period, especially, they have to perform and close, even if they find something, unfavorable, which we all know in vacation rentals, these owners aren't in. Um, so am I in any kind of risk by not asking or knowing that? Or am I putting the agents at risk by not
Well,
asking or knowing that?
I would think that each contract would stand on its own independently, the short-term
Mhm.
vacation rental contract and the
Right.
purchase and sale contract. And I think it'd be dangerous for you to unilaterally make a decision on that. I would go
Mm-hmm.
to Tony Barros or whoever you use for legal advice and say, hey, these people want to rent this through our short-term vacation rental process, and they're going to
Right.
close on it, simultaneously, whatever. And
Yeah.
because there's,
Yeah.
I'm sure there's problems somehow with that, right? That can
Yeah.
pull back on you.
Yeah, I would
Absolutely.
think so. Yeah, I would think so.
Absolutely. It's a good question for Patrick.
Okay.
Okay.
Yeah.
Patrick Stevens. Because they are two things that are independent of each other. And I think it's a very good question to ask Patrick or Tony Barros, ask one of them. Okay. And then let us know what the answer is to that.
Okay.
Okay. Anybody have anything else? No? Well, thank you all for joining Jeff and I this morning, and a lot of good questions, and I hope we helped you here and made some of these things a little clearer and what they are and how to work with them and how to explain to both buyers and sellers what the impact is on them, and also um, all those embedded dates and things that are in there. I hope that we've kind of brought them to the surface so that they're there and you're managing those dates. So, well, thank you all very much. I'm going to put this slide deck is going to go into Back at You under Master Series. All of them are there, I think. And then Frank will post it to the YouTube channel. So if you have any questions, call me, call Jeff. We're happy to answer your questions. And thank you all again for participating this morning.
Nice job, Ruth. Thank you.
Thank you,
Thanks,
Jeff.
Ruth.
That was great. Thank you.
Okay. Feel better, Chrissy.
Thank you.